Mediation isn't just about keeping the peace, it's about guiding two sides through conflict toward meaningful resolution. The best mediators are calm, clear, and strategic, but above all, they know how to use language to reduce tension and build trust. In this lesson, you will learn how to mediate legal disputes in English using precise vocabulary, diplomatic tone, and professional softening techniques to lead effective mediation sessions. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons, plus community support, and most importantly, live sessions, join us in our legal English community. The link is in the description. Today's lesson focuses on one of the most delicate tasks in legal practice: mediating between disputing parties. Whether you're working in family law, commercial disputes, or international conflicts, your ability to stay impartial, establish clear ground rules, and guide parties towards resolution is critical. But it's not just what you say, it's how you say it. We will explore softening devices and indirect language that reduce tension, avoid escalation, and help both sides feel heard. You'll learn how to redirect anger, set expectations diplomatically, and create space for agreement, all in professional, advanced legal English. By the end of this lesson, you'll be able to facilitate a mediation session in English using language that's calm, persuasive, and legally precise. Let's begin by activating your thinking. What comes to mind when you hear the word mediation? Maybe you picture two people who won't speak to each other, sitting across a table, arms crossed, and your job is to help them talk. Maybe it's a contract dispute, a family issue, or a cross-border conflict. As a mediator, you are not a judge. You don't take sides. You help the parties talk, listen, and hopefully find a resolution. You might say mediation is useful when both parties want to avoid the cost and stress of a trial. A mediator should always be impartial and focused on solutions. It's important to set ground rules because emotions can run high and structure helps keep the conversation productive. This is the foundation of today's lesson: calm, strategic communication that helps people move forward. Being impartial is the foundation of effective mediation. You are not there to take sides. You are there to create a safe, neutral space where both parties can speak and be heard. The mediator must remain impartial throughout the negotiation. This means showing no bias, not through your words, your tone, or your body language. If a party feels like you're siding with the other, trust breaks down fast. In your communication, use balanced phrases like, "Let's hear both perspectives on that point. I want to make sure each of you has time to speak." Impartiality builds credibility and makes resolution possible. In legal contexts, a resolution is more than just an agreement. It's the end of a dispute. Sometimes it's a written statement, sometimes it's a verbal understanding, but the key is that both sides agree to move forward. Both sides reach a resolution through mediation. This tells us the mediator helped the parties communicate, compromise, and ultimately agree on terms. You might say during a session, "Let's explore what a workable resolution might look like. What terms would feel fair to you at this stage?" Resolutions are the goal of mediation, but they're built on trust and process. Ground rules help prevent chaos. They create structure, especially when emotions are running high. In mediation, ground rules might include no interruptions, use respectful language, confidentiality, speak from personal experience, I statements. For example, we began the mediation by agreeing on ground rules for respectful communication. You might say, before we begin, I'd like to set a few ground rules to keep this productive. Let's agree that each party will have uninterrupted time to speak. Clear rules make difficult conversations safer and more effective. To facilitate means to help things move forward, especially when communication is tense or complex. Mediators don't solve the problems for the parties, but they guide the process. For example, the mediator facilitated a productive dialogue between the two sides. This could mean rephrasing a hostile comment, summarizing key points, or asking clarifying questions. For example, let me rephrase what you just said to be sure I understand. Or can we take a step back and look at the bigger picture here? Facilitation is an active skill, and language is your most important tool. In mediation, your job is to prevent conflict from escalating, that is, from getting worse. For example, interruptions and accusations can escalate the conflict. Suddenly, voices rise, emotions flare, and the parties stop listening. This is when the process can fall apart. As a mediator, you might say, let's pause for a moment and refocus. I understand that this is emotional, but let's try to stay constructive. Recognizing and de escalating tension is a key part of the mediator's role. A concession is a compromise, a way to move forward by giving something up. In mediation, each party may need to make concessions to reach agreement. For example, the claimant made a small concession to keep negotiations moving forward. This doesn't mean losing, it means being strategic. You could say, would you be open to making a concession on that point? Sometimes small concessions lead to big breakthroughs. It's all about choosing what matters and what you're willing to give. Common ground is what brings people together, even during conflict. It might be a shared goal, a mutual interest, or even a desire to avoid court. We began to identify common ground after delivery timelines. Mediators look for these entry points and build from there. For example, is there any area where you both agree, even partially? Let's try to identify some common ground before moving to more difficult issues. It's easier to build a bridge when you find a place to start. A breakthrough is a moment when things shift, often after hours of tension or silence. For example, there was a breakthrough when both parties agreed to reconsider the payment structure. Sometimes it's a new idea, sometimes it's a change in tone, and sometimes it's just the right question, asked the right way. For example, what would it take for you to feel comfortable moving forward? Or let's explore a few alternatives. There may be something we haven't considered. Breakthroughs aren't always dramatic, but they can turn a stalemate into a solution. Let's imagine a commercial mediation. One part accuses the other of bad faith. The mediator listens calmly, then turns to the other side and says, "You will have equal time to share your view." She doesn't show emotion, doesn't take sides, just keeps the process moving fairly and respectfully. What's the legal English term for this essential quality? Impartial. An impartial mediator creates trust, not by solving the problem, but by making sure the process feels balanced for everyone involved. Before beginning the session, the mediator says, let's all agree. One person speaks at a time. No personal attacks, and let's keep this confidential. These agreements set the tone. They prevent chaos and help manage expectations. What's the term for these pre-established expectations? Ground rules. And ground rules are the backbone of any productive mediation. They protect the process when emotions get heated. After 4 hours of disagreement, something shifts. One party says, okay, if you are willing to reduce the penalty, we will cover the remaining costs. The other party pauses, then agrees. The entire tone changes. Suddenly, progress feels possible. What's the word for this kind of shift in momentum? The answer is a breakthrough. And a breakthrough doesn't always come from force, it often comes from timing, language, and well guided dialogue. In mediation, tone matters just as much as content. Direct statements can sound confrontational, even if they're legally correct. That's why experienced mediators use softening devices, polite, indirect phrases that reduce tension and invite cooperation. Let's look at a few key examples. Perhaps we could look at another option. This is gentler than that won't work. Or would you be open to changing the timeline instead of you need to change it? Or let's try to explore some middle ground. This sounds collaborative, not demanding. Or it might be helpful to clarify expectations instead of blaming someone for being unclear. Or I wonder if there's flexibility on that issue. This invites discussion, not resistance. In legal English, softening devices don't weaken your position, they strengthen your ability to manage difficult conversations with diplomacy and professionalism. When tensions rise, a direct statement can escalate the conflict. That's why mediators often use indirect language. It allows you to express disagreement or suggest alternatives without triggering defensiveness. Let's break down a few examples. It seems there may have been a misunderstanding. This avoids blame. You're not saying who's at fault, just inviting clarification. Another one. There appears to be some disagreement on the timeline. This is softer than saying, you're wrong about the deadline. You might want to consider another approach. You're guiding, not commanding. There could be a way to meet halfway. This opens the door to compromise. Or, I'm not sure that suggestion would be acceptable to both parties. This signals concern without rejection. Indirect language and mediation isn't vague, it's strategic. It helps maintain a calm tone while still moving the conversation forward. Let's practice turning confrontational language into diplomatic, professional mediation speech. Your task is to rephrase each sentence using the softening tools we've learned. I'll give you an example for each. You are not being realistic. You could change that to, perhaps we could look at some more practical options together. Number two, this is your fault. We can change that to, it seems there may have been a breakdown in communication on both sides. We already told you that won't happen. Two, as we mentioned earlier, that option may no longer be available, but let's explore alternatives. Number four, you need to lower your expectations. Two, it might be helpful to revisit what outcomes are most important right now. Number five, that solution is unacceptable. I'm not sure that proposal would meet both parties' needs. Would you be open to revising it? These small shifts can completely change the energy in the room. They help you keep the conversation productive, even when it gets difficult. When mediation gets tense, the first breakthrough often comes from finding even the smallest shared value. This is called finding common ground. For example, we're here to find common ground and move forward. This phrase means identifying any area where both parties agree. A shared goal, a mutual need, or even a desire to avoid court. As a mediator, you might say, let's begin by identifying where you do agree. Or if we can find some common ground, we will have a foundation to build on. In legal mediation, finding common ground isn't the final step, but it's usually the first one that moves the process forward. Sometimes negotiations stop moving entirely. Both parties refuse to budge. That's a deadlock. Your job as mediator is to help break the deadlock. For example, the mediator suggested a payment plan to break the deadlock. This means proposing a creative or acceptable compromise that restarts the conversation. You might say, would you be open to a short break to rethink your position? Or, let's brainstorm a few options to break the deadlock. In legal English, this phrase is practical and professional. It signals movement when there is only once a gridlock. Every negotiation has limits. When one party refuses to go further on a specific issue, we say they've drawn a line in the sand. For example, the supplier drew a line in the sand regarding penalties for late delivery. It's a powerful image, a point you won't cross. As a mediator, you must recognize when a line is firm and when it might move. You might say, is that an absolute position or is there room for flexibility? Let's explore whether that line in the sand is necessary or strategic. This phrase is especially common in business or commercial mediation and signals that a key issue may need special attention. In mediation, there's always a risk that one party might stop negotiating entirely. They may walk away from the table. For example, the buyer threatened to walk away from the table if the offer wasn't improved. This means ending the discussion, sometimes temporarily, sometimes permanently. It can be a pressure tactic or a sign of real frustration. As a mediator, you might say, before walking away, let's consider what's still possible, or what would need to change for you to stay at the table. This phrase is useful when discussing last resort scenarios or analyzing failed negotiations. Let's imagine you're leading a mediation session between two business partners in dispute over a failed delivery contract. You begin the session calmly and impartially, stating, let's begin by reviewing the ground rules. One person speaks at a time and will keep all discussion confidential. We're not here to assign blame, but rather to find common ground and move toward a possible resolution. The first party accuses the other of negligence. The second threatens to walk away from the table. You step in with a soft, professional tone. It seems there may have been a misunderstanding about the delivery timeline. Perhaps we could explore what each party expected at the time and whether there's any flexibility now. As the discussion intensifies, you notice it's about to escalate. You reframe with diplomacy. Would you be open to pausing briefly to clarify priorities? Or there could be a way to meet halfway that preserves the relationship. Eventually, one side offers a concession, a partial refund with adjusted payment terms. You summarize. That proposal might help break the deadlock, especially since it aligns with your earlier concerns. Or, I'd like to acknowledge this could be a potential breakthrough. The mood shifts. You continue to facilitate the dialogue until both parties sign a draft agreement. You close the session by affirming, this wasn't easy, but both sides showed flexibility. You have moved from conflict toward a structured, workable resolution. This is what it means to mediate in legal English. Clearly, calmly, and strategically, using the right vocabulary, grammar, idioms to guide high stakes conversations. Let's take a moment to reflect on what you have mastered today. First, we explored high level mediation vocabulary. Words like impartial, resolution, and ground rules help you guide legal disputes with clarity. Then we practice softening and indirect language, essential tools for reducing conflict, reducing tension, and managing difficult conversations with diplomacy. We also learned legal idioms like break the deadlock and walk away from the table, phrases that add depth and fluency to your professional legal English. And finally, we brought it all together in a real world story, helping you speak like a skilled mediator, English speaking legal settings. Whether you're leading a family dispute, a commercial conflict, or an international mediation, these tools will help you sound confident, impartial, and professional. Do you want more lessons like this with real feel? Do you want more lessons like this? In our legal English community, we combine this with real feedback and live sessions. Join our legal English community. The link is in the description, and see you in the next lesson.